Thanks, Mr. Speaker. I rise to make a contribution to the Crimes Amendment Good Character Bill, and I'm glad we've landed where we have. Because if you commit a crime, you're accountable under the law. No amount of prior good deeds, community involvement, or perceived moral standing should ever be used to soften the consequences of that offending. It has an effect on the victim. Because good character is not a shield, it's not a shortcut, and it should not result in leniency or a get out of jail card. Because if you're found guilty, are we actually really talking about good character? This bill removes good character as a mitigating factor in sentencing by amending the Crimes Sentencing Procedure Act 1999 and abolishing the common law principle that has allowed it to stay and be used in that way. And that change, in my opinion, is well overdue. For too long, we have seen a system where the focus drifts away from the victim and back onto the offender's reputation. Well, what about the victim's reputation? As though, that offender, their good standing, in the community somehow balances out a serious criminal act. And it does not. It's not possible. So for the victims, it can be confronting and at times insulting to sit in a courtroom and hear how good the person who's harmed them described, how good a character they're described as. And, we then forget, how much harm has been done to the victim. And I don't want to stand by and say that, or stand by while we are minimising that harm. It undermines the confidence that the justice system is actually focused on what it's there, how it's named, the justice. So victims should not have to sit through these proceedings where that reputation is used to soften the consequences of that offending. And, offenders are sentenced for what they did, how they did it, and not for how they were perceived before they did it. The Attorney General's Sentencing Council's report recommended that good character be abolished as a mitigating factor at sentencing for all offences. There were several concerns that have been brought up, and I agree with them that the concept is inherently vague. It's subjective and it's difficult to determine. There is no evidence that good character reliably predicts rehabilitation or a reduced risk of reoffending. And I really want to focus on that because you can make a mistake and that is against the law, and that is then classified as an offence. You should not then get off that offence what the prescribed punishment for that offence is just because in the past you're a good character. We have the increased harm to victims having to rehear how good that victim was and how minimal the offence was. And the potential for inequality during sentencing is a major point. And I really think that, if you've got someone that has access to a previous good behaviour character reference, and there's plenty of people in my electorate who come from a low socioeconomic environment, and they don't as easily access the good character references. It certainly advantages those with higher social standings or the perceived respectability to others. And it's certainly not about removing fairness from either the court process or sentencing. Courts will still consider everything that actually matters when they determine a just sentence. Whether someone has prior convictions, whether they're likely to reoffend, whether they have genuine prospects of rehabilitation, and all relevant personal circumstances properly before the court. Nothing in this bill stops a court from doing its job properly, and that's really important because, what it does stop is good character being used as a vague catch-all reason to reduce the accountability of someone who has offended and been found guilty. We also note the concerns raised by the Aboriginal Legal Service and Domestic Violence New South Wales, particularly around domestic and family violence and the risk of misidentification. Those are serious concerns. In my electorate, we have high rates of domestic violence, and misidentification is not theoretical. It can be real and it can have real consequences. That is why it is critical that those issues are addressed properly through separate processes and not blurred into the sentencing reform where they really don't belong. The government has indicated that work will continue in that space, and it must follow through with that commitment, because we cannot afford a system where the wrong person is blamed or where sentencing principles unintentionally add to that harm. But we also cannot maintain a system where an offender's reputation is allowed to soften the response to serious criminal conduct. This reform is needed because it draws a clear line. Sentencing is actually about conduct, the consequences of their action, and harm, not the offender's reputation. If you commit a crime, you face the consequences, and those consequences should reflect what was actually done, not how someone was seen in their community beforehand. Good character does not undo the harm, it does not lessen the pain. If anything, it actually enforces it. And it should not reduce accountability. This bill does strengthen clarity and consistency in sentencing, and it ensures the focus stays where it belongs, on the offence, on the offender, and not on the victim. And on the victim. For those reasons, I do not oppose the bill.
I thank the member. The question is the bill